Hi everyone, in this week's dispatch video we will be focusing on potential reform of restrictive covenants in employment contracts. So when we say restrictive covenants, we mean post-termination restrictions that are put into generally senior contracts of employment, and these can prevent employees from competing after employment, soliciting customers, soliciting staff, creating or making a presumption of a continuing association with their former business. There was a 2020 consultation on reform of one particular area, and this was non-competition. So a prevention after employment for a period of time on working for a direct competitor in the competing services. That was a limitation in scope of the consultation. It's taken nearly 3 years to do anything about it, and the response has now been published. So there was a suggestion that non-compete clauses would only be enforceable in the future if they were supported by consideration, i.e. if the employer agreed to continue paying the individual for the period of the restriction. That hasn't been taken forward, probably because it would render the clause pretty useless. So an employer might as well just extend the notice period and have a garden leave provision in there. There will be some guidance produced on non-compete clauses. Respondents to the consultation suggested that if employees were more aware of their rights and the enforceability of such clauses, it would provide greater fairness and transparency on the law. Now, most importantly, the government has confirmed that they will introduce a 3-month limit on non-compete clauses in employment and worker contracts. This is described as bold action to boost labour market flexibility, reduce barriers to recruitment, and to ensure businesses of the future can access the talent they need to succeed. The suggestion is that the average non-compete clause lasts for 6 months. It can range from 1 month to 24 months. Hopefully this maintains some flexibility. That's the view of government anyway. Now, the 3-month cap will only apply to non-compete clauses, so the less restrictive measures such as non-solicitation, non-dealing in relation to customers and staff, that will not be affected by these changes. Now, interestingly, the cap only applies to employment contracts and worker contracts. Often we see that restrictive covenants are contained in partnership agreements, LLP agreements, shareholder agreements. The view is that parties tend to have more bargaining power. It's not as unequal in those situations. And so it's likely that we'll continue to see those being enforced in just the same way as now. It's important to note that if the non-compete clause is three months or less in total, that doesn't make the clause enforceable. The position at law is that any restraint of trade clauses are unenforceable unless they are shown to be reasonable, so go no further than is necessary to protect the legitimate interests of the employer. So a total ban is outweighed by the benefits of introducing a 3-month maximum on restrictions. The government thought that other restrictive covenants and confidentiality clauses might be made too strong in response if there was a complete ban on restrictive covenants. Garden leave use would increase, and there would be tightening of sharing across other organisations, which can affect the competitiveness of industry generally. And would there be reduced investment in training and upskilling workers? If businesses feared that staff were just going to leave as soon as they were fully trained, there might be a lack of investment in that going forwards. Now, there's no indication of when the cap will come into force. It simply suggests, as always, when parliamentary time allows. I'm not sure whether it's going to be pushed in the lead up to the next general election, but we'll see. If that cap is brought into place, employers will need to start to look for other ways in which they can protect their interests, largely in reference to very senior employees where other restrictions are not likely to have the protection that's desired. So businesses may look at lengthening notice periods, bulking up garden leave, bulking up other restrictive covenants, confidentiality and intellectual property clauses, and that may in turn see more increased litigation in those areas. Will businesses also consider entering into other agreements? So we know that the limit is going to be enforced only in relation to employment contracts. This may increase the number of employee-owned businesses, shareholder agreements, LLP agreements, where we invite people in and use restrictive covenants in that way. So there could potentially be an employee ownership issue to get around that and build in better protection for the employer. There's a number of other questions that remain unanswered. So if we have existing contracts with 6-month non-compete clauses, how are they going to be affected? We don't know. Will the 3-month, will any restrictions in excess of that be enforced just up to 3 months? That remains to be seen. And the other unanswered question is in relation to settlement agreements. So when an employee leaves the business, if they do enter into a formal settlement agreement to record the terms and usually provide an enhanced payment, the employer will often want to impose more onerous restrictive covenants in return for an enhanced payment. The consultation and the response isn't clear in stating whether or not we can build in lengthier non-compete restrictions into there. But again, that could be an option if we desire more protection than the law is going to allow. So we await further news on implementation. In the meantime, if you need any assistance on post-termination restrictions or any employment matter generally, do get in touch. Visit the website chadwicklawrence.co.uk or email employmenthub@chadlaw.co.uk. Thank you.